Next up, is the new Dutch regulatory framework for iGaming dead on arrival? An in-depth discussion with our panel. You are watching GLG. Game on. But first, for our main story this morning, an in-depth look at the changing nature of corporate iGaming substance. Let's check in with our friends at iGamingdatabase.com. With us today, our panel, Cosmo from Legal Tech, and Lulu, anti-money laundering specialist. Good morning, everyone.
Hi.
So let us dive in. If I understand you correctly, in your article, you discussed that the way a legal location of an iGaming company is determined is changing. Why is this important?
Thank you for having us, Trisha. Yes. It used to be quite simple to determine the location of an iGaming company for legal purposes. However, this is changing. In a ruling of the Dutch court, it was determined that the iGaming company PokerStars, for Dutch gaming tax purposes, was not located within Isle of Man. That would be outside of the European Union, but rather in Malta, where the structure holds its license. This had important legal ramifications for the levy of gaming tax in the Netherlands. The Supreme Court in the Netherlands did already determine that Dutch legislation on the levy of gaming tax is not compliant with the freedoms of the European Union. As a result, Dutch gaming tax may no longer be unconditionally levied from end users playing on websites within the European Union. Since it was ruled that the PokerStars website should be seen as a European website, this resulted in a ban on gaming tax. The matter has been partly overturned now, but you see that discussions on location and substance can have substantial consequences.
As I understood from this ruling, a lower court ruled that the entity within the structure holding the license should be seen as the center location of the iGaming company. Was this because of the location of the server?
Correct. It is quite ridiculous. Really. In the article, we describe that the so-called e-commerce directive also uses the location of a server to determine which nation is allowed to levy tax. However, this train of thought is hopelessly outdated. Nowadays, servers are placed on certain locations, for all sorts of reasons, anywhere and everywhere. The point is, one cannot determine the center of an iGaming company by location of its server. We would never hear the end of it. What would be next? People setting up fake server buildings? Empty office rentals? That may even qualify as tax evasion.
What advice would your team offer to our viewers?
Well, firstly, we would like to recommend your viewers to read the article. Find it at gaminglegal.com/substance. Secondly, always work on a proper plan to structure corporate gaming substance. If point A contacts point B every time there is a problem for feedback, then substance needs to be allocated to point B. Pretending that point B does not hold any substance does not make sense. Thirdly, please do not rent empty office buildings. It is silly, and it does not work.
Thanks, guys. Did you find this item useful? If so, may I recommend subscribing to our channel? It is 100% complimentary. Thank you. Until next time.